Okay, this is Mike Benoit, and I'm going to discuss with you today, or I'm going to document today, my response to the government's motion for summary judgment in my tax case where the IRS took my house. And again, briefly, summary judgment is a process where the court, the judge, makes a decision based on the idea or the concept that there are no disputes in the facts, and he's just going to apply the law. But in the case of the government versus the citizen, with the government in the seat of judging, well, it's not a good idea. That's why we're guaranteed trial by jury, is for tyranny and government. Anyway, I'm fighting in this case. I was fighting for my right to have a trial by jury over this IRS claim that I owed them tens of thousands of dollars, up to $144,000. And I just wanted the trial by jury, which I didn't get. But the video 3 is discussing the government's motion for summary judgment. And again, on summary judgment, to re-emphasize the point is that when there are no disputes on the facts, or the material issues of facts in the case, then the judge will make a decision based on the law. So, of course, what they do is decide that there's no issues, material issues of fact first, when there is, and then they go ahead and decide the merits of the case on the law, so to speak. And it's very difficult to even explain this stuff and for the average layperson to go through, but we only understood one thing: a guarantee of trial by jury is a guarantee of trial by jury. Taking somebody's property without trial by jury is an abomination to the Constitution. Hopefully some folks that have some legal training will take the time to listen to these series of tapes. Anyway, in my submission for opposition to the plaintiff's summary judgment motion, first thing I do is I make an objection to the plaintiff's exhibit that was submitted in their motion, and I'll go over that later. But the government had mentioned their material facts, so I have a list here of material facts. The government's material facts were basically non sequitur to the case, if you will, inaccurate and immaterial. My statement of facts are a little more succinct, but a lot of good that did me. Anyway, real quick, first statement of fact is that I did not have taxable income for the years in question, 95 and 96. Second, I did not have income subject to self-employment tax, which was part of the alleged assessment. I did not have a tax year for 95 and 96. The action was brought against somebody named Michael N. Benoit, and my name is Michael Benoit. I don't have a middle name. All the evidence produced by the plaintiff is for Michael N. Benoit. I did not receive compensation from the flyer service in 1995 and 96, like the government claimed, and they misstated my deposition. My deposition clearly says different. Plaintiff has repeatedly failed for over 12 years to produce the code sections that impose the tax on me, the defendant, or any assessments in the matter. That's fact. Plaintiff has never demonstrated that the defendant had taxable income. The first set of forms 4340 was not produced until April of 2007, and these are supposed to be a record of assessments and collections, and the government did not, and this is for years 95 and 96. So they never produced this form 4340 until the year 2007, and that's significant, and you'll find out later if you watch this. The second set of forms, 4340, produced on 11/23/2009, are not identical to the first set. Substitutes for returns have been listed as having inconsistent dates, as having been destroyed, or having never existed. And substitutes for returns are quite important for the imposition of any tax or any assessment. The failure to pay assessments dated 10/23/2006 listed on Form 43 for 95 and 96 dated 11/23/09 were made outside the statute of limitations. There was no deficiency sent regarding this alleged assessment. Defendant's property is protected by a homestead declaration. A lot of good that did. The defendant, Benoit, is not subject to accuracy-related penalties or late filing penalties. Plaintiff is attempting to collect failure to pay penalties twice for the same years. Issues presented by the plaintiff, whether or not Benoit is indebted to the United States for $144,000, blah, blah, blah. Whether the United States is intended to foreclose for federal-related tax liens on the parcel of real property. And my argument. The plaintiff references on page 2 of 26 their points and authorities that the defendant Benoit received copies of IRS certificates of assessment, but neglects to state that they were sent in 2007, over 8 years after the alleged assessment. And in 2009, plaintiff starts her arguments in her statement of facts on page 3. The plaintiff states that taxes were assessed on 11/23/1988, which is before 1995 and 96, the years in question. Plaintiff argues nonsense on page 3, line 16 through 25. A substitute for return with the date of 9/29/1997 with an assessment amount of 0 does not demonstrate that assessments were based upon examination by the IRS. Neither the notation of additional tax assessment by examiner nor the notation of statutory notice of balance due demonstrates that assessments were properly made. The plaintiff has submitted copies of 4340 for 95 and 96 as Exhibits 1 and 2. And an additional set of these forms submitted as part of the Exhibit 7 dated 9/18/2006. Both sets of the forms relate to Michael N. Benoit, not Michael Benoit. This improperly named defendant is Michael Benoit. Title and subject property is vested to Michael Benoit. All the governments reflect a Michael N. Benoit. Defendant is not Michael N. Benoit. Defendant Benoit had not received copies of 4340 until 2007. That a substitute for return was entered on, and they show that a substitute for return was entered on 9/29/1997, which lists an assessment of $0 with the date of 11/3/1997. Both sets show a late filing penalty of $2,462. Miscellaneous penalty, IRC 6662, of an accuracy-related penalty of $1,563. And additional tax by examination, $7,816, $3,002, all with assessment dates of 11/23/1998. The set of 4340 forms created for and submitted with the plaintiff's motion for summary judgment dated 11/23/2006 reflect an additional entry for failure to pay tax penalty and an assessment date posted 10/23/2006. Plaintiff Exhibit 5 shows a failure to pay penalty 703.44. You know, this is kind of getting there, and it's kind of like, here, you know, what's all that about? And of course, these are not copies of assessments. this is a form created in 2007 to show evidently some computer records. And I'm sorry to put you through this. I'm sorry to even I have to read this stuff again because all the stress I went through in the first place. Anyway, I'm contesting all of this, and that not only they've got assessments in there for self-employment tax. Not only did the defendant not have taxable income from the years 95 and 96, he did not have income subject to self-employment tax, nor did the government ever show him a code section that might have imposed such a tax. So I go on, okay, and maybe all of this stuff will be a little Greek, and even though it's germane to looking at the whole process, it may be a little much, so I'll skip a little bit. Let's go down to, and I'm listing the different things that just don't make any sense, that will show that there are issues of material fact for a jury to look at. All right, so looking at these failure to file tax return or pay penalty assessments. In 6651, it says, in case of failure to file any return required under authority of subchapter A of chapter 61, unless it's shown that such failure is due to reasonable cause and not due to willful neglect. Now, during that period of time, and I do present this evidence to the court, I'm communicating with the IRS constantly, saying that I don't owe any taxes, that show me where that you think I owe taxes, where the code section is, etc., etc., etc. And if you know, then I assume you agree with me that I don't owe any taxes and that I don't have to file. So when you think it's unless it can be shown that failure is due to reasonable cause and not willful neglect. Well, and again, I'm just saying, I give evidence that this is not willful neglect. I got cause why I'm not filing return. Because I've studied this and I don't owe any taxes and I don't have any taxable income. So this section 6651 can only apply if there's willful neglect. And then it lists 5 conditions where it applies. Negligence or disregard of rules or regulations. And they wouldn't show me any rules or regulations that I was disregarding. I'm asking for them, and they wouldn't give it to me. So there's no negligence on my part. I was very diligent. That was the only thing in this 5 things that could possibly apply. An understatement of income tax, well, if you don't file, there's no understatement. Any substantial valuation or misstatement, obviously I didn't do that. So failure to file tax return or to pay tax, additional to the tax. And so these 5 conditions that they list, none of them apply to me. So yet, that's part of the $144,000 they say they owe. That's a material issue that the jury should be deciding. Not the judge looking at this and saying, let's see, this guy isn't paying taxes, the IRS says he owes taxes, summary judgment in favor of the IRS. Okay, so those things didn't apply to me. You go on, there's more on that one. Another reason I give that summary judgment doesn't apply to me and isn't okay. I mean, there's a whole bunch here, but this will take a couple hours to list them all. So I'll go to item 2 now here. The plaintiff relies on these certificate of assessments to create presumptive proof of evidence of assessments. And the court cases on this state that these certificate of assessments and payments is usually to prove that a tax assessment has in fact been made. There's a list of court case, United States versus Chile, United States versus Miller, United States versus Dixon. And then a certificate of assessment and payments is presumptive proof. Okay, so they're going to give them the advantage. They have presumptive proof that the tax has been assessed. But that presumptive proof is only there where the defendant has produced no evidence to counter this presumption. Now, I've produced evidence to counter the presumption. I mentioned some of it right there. That so just these penalties, that there are no records of assessment. I've asked for records of assessment. And then the 4340 form, I've asked for that, and they're supposed to send that to you. I'll get to that in a little bit here. So it's where, summary judgment is proper when there is no evidence to counter the presumption that the government gets with this form 4340. The introduction of presumptively correct assessments shifts the burden of proof to the taxpayer. If the taxpayer rebuts the presumption, it disappears. And I did. In a suit to collect tax on unreported income, the burden of proving the deficiency then reverts to the government. So I've produced a plethora of evidence rebutting the presumptive evidence. Now, the plaintiff argues in Hughes versus United States, forms 4340 are highly probative in the absence of contrary evidence is sufficient to establish that an assessment was properly made and that notices and demands for payments were sent. And this is a requirement. Well, I've got evidence to rebut that presumption that the assessments weren't properly made. I agree with the Hughes court, and I've demonstrated by contrary evidence that assessment was never properly made. But the form 4340 forms do have defects in the two sets, and they're not the same, and they're materially different. The 2007 or 6 set shows an original assessment of $14,857.42 for 95 and $50,017.08 totaling $64,874.50 for 96. The set dated 11/23/2009 shows original assessments of $16,811 and $57,501.58 totaling $74,313. So there's two sets of Form 4340 with different original assessments amounts. Significant in that one is $10,000 higher than the other. So this is like, which one's right? The court, or neither right. The court in Huff found that this condition was one of a genuine issue of material fact. Like in the Huff case, Benoit has not received any copies of these assessments pursuant to the requirement of 6203, even though he's asked for them repeatedly. And in Huff, given the defects in the Form 4340 and the fact that the record contains no evidence indicating the Huffs received copies of their assessments pursuant to their request under Section 6203, we conclude there are general issues of material facts as to whether the IRS has complied with this requirement. My case is exactly as that. So it should be, all right, let's go back and give this guy a trial. The Form 4340 can be used as presumptive evidence in the absence of contrary evidence. The court stated that the record contained no evidence that Huff received copies of their assessment, which certainly means that assessments are not Form 4340, but are entirely different things. Like in Huff, Benoit has not received any copies of assessments, and like in Huff, the Form 4340s are highly suspect in that the two sets are quite different. These computer-generated Forms 4340 were not presented to me until April 2007 and November 2009, even though I had numerous demands for them and FOIA requests likewise for them from the years 96, 97, and 98 forward. All right. The court must not consider granting a summary judgment based on the Forms 4340 without giving the defendant an opportunity to cross-examine the authors of these conflicting forms or conflicting documents. The granting of summary judgment in favor of the government in the light of the long-standing track record of 14 years plus, dating back to 95 and 96, of the government's failure to produce either the code sections that made defendant liable for taxes or assessments of taxes simply would be a heinous affront to due process and justice. So in actions, the U.S. has filed a lien. The IRS office that filed the lien needs to be identified in the complaint. That wasn't done. In regard to failure to pay penalties listed on 4340 for 95-96 with assessment date. Title 26, Rules, Title 26, Section 6671, Rules applicable of assessable penalties. Penalty assessed as tax. The penalties and liabilities provided by this subchapter shall be paid upon notice and demand by the Secretary and shall be assessed and collected in the same manner as taxes, except as otherwise provided. Method assessment. The assessment shall be made by recording the liability of the taxpayer in the office of the Secretary in accordance with rules and regulations. Notice of demand for tax. Where it's not otherwise provided by the title, the Secretary shall, as soon as practical and within 60 days after the making of the assessment of the tax pursuant to 6203, give notice to each person liable for unpaid tax, stating the amount and demanding payment thereof. 6501, limitations in assessments on collections. 6020 authorizes the Secretary to execute certain returns. The substitutes for returns do not exist in this case. And then you'll see in my motion for summary judgment that I'll go over next, or next, that I've got a letter affirming that there are no substitutes for returns in this case from my many FOIA requests. So we have that. So I'm presenting enough evidence to rebut the presumption of guilt in the IRS cases. You know, America is supposed to be different than other countries around the world, presumed innocent instead of guilty. And under section, under the Code of Federal Regulations for method of assessment, it says, if the taxpayer requests a copy of the record of assessment, he shall be furnished a copy of the pertinent parts of the assessment, which set forth the name of the taxpayer, the date of the assessment, the character of the liability assessed, the taxable period, if applicable, and the amounts assessed. It's without question that the government did not comply with Title 26, Section 23, 6203 of that code. So I submit my affidavit. Sworn testimony, and this sworn testimony is based on my personal knowledge. As in further tape here, we'll show how the government's evidence submitted was not submitted according to rules and regulations, and therefore was not really ever even submitted. But, that the process requires a certain method of submission, and if that's not complied with, then the evidence is supposed to be disregarded. Kind of like hearsay is disregarded, and most of us know what that means, right? All right. So then I had my objections to the government's exhibits that they put in there, and I submitted that at the same time. And this is what I was just talking about, Rule 56. Now, in looking at this, I could have been better at spelling it out, but I'm not sure if it would have mattered at all, because I didn't spell out why the government failed under Rule 56E directly. I just kind of had 56E be self-explanatory, and it wasn't. But But anyway, here I object to their evidence and the basis that it was submitted in violation of Rule 56C. And for summary judgments, in supporting or opposing affidavit must be made on personal knowledge. Set forth facts that would be admissible in evidence and show that the affiant is competent to testify on the matter stated. Now, that wasn't the case. The IRS attorney that submitted this evidence submitted under knowledge, under information and belief, not on personal knowledge. And I could read that, but that's what her declaration says: information and belief. And that's not good enough for this. A sworn or certified copy has to be attached. Defendant Benoit can find no authority for the submission of exhibits as evidence absent an affidavit pursuant to Rule 56E. And then the court case goes on to that, to speak to that. How Roach Studios, Inc. versus Richard Feiner and Company, Inc. Rule 56E provides in pertinent part that supporting affidavits shall be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matter stated therein. Sworn or certified copies of all papers or parts thereof referred to in an affidavit shall be attached thereto or served therewithin. It is well established that unauthenticated documents cannot be considered on a motion for summary judgment. In court cases here, the court may properly disregard these documents. All right, so I further object to the plaintiff's alleged material facts submitted by the government, and some different objections. Plaintiff's statement of material facts is presidential, lacking foundation. Plaintiff's statement of facts, item 1, plaintiff misstates Benoit's deposition, as he never stated he worked at the building inspector. Facts 2 and 3, relevancy. Plaintiff misstates the testimony and plaintiff's statement of material facts. Benoit admitted to his signature being on copies of the front side of checks showing his name as a PE, but not that they were checks for compensation, and that they were even received or cashed. In plaintiff's statement of material facts, she misstates the plaintiff's deposition on page 22 of said deposition. Defendant Benoit, in reference to the flyer service, states, "I don't know if it started in 96 or started in 97, I'm not sure." And in her summary judgment, she says that I received income from the flyer service in 95 and 96. She got no reference for that other than the deposition. And my deposition says, I don't know if it started in 96. I think it was 97, I'm not sure. I objected to the plaintiff's statement of material facts number 8, 9, 10, and 13 as being irrelevant and prejudicial. Objects to the plaintiff's statement of material facts 15, 16, vague and overbroad at the time. Nothing about these statements make reference as to whether these documents were sent according to regulation. So that's the objection to the statement. But if you look at it, all the evidence that she submitted, there was no evidence that was submitted on the Rule 56E that applies, that has to be there for summary judgment. And keep in mind, I'm not trying to win a case so much on summary judgment. I'm trying to get a trial by jury. They're trying to do something different. And so that's the United States motion for summary judgment. And there'll probably be a reply to this, and that'll probably be the next thing. I'll find the government's reply to this opposition and go through that. And then after that, I will submit my motion for summary judgment. So, which I had to put, because really, if they can't produce assessments, then there's no material issue at stake, and I should get summary judgment. And they never did produce any assessments, nor followed the rules. And so if they don't have a case that they can hang their hat on, then I'd be the guy that'd be entitled to summary judgment, not them.